start this. Okay. Last time we were talking about sources of law, and we specifically discussed legislation and the interpretation of statutes, the fact that statutes are passed and published chronologically, but they are also codified into codes, which give you subject matter access to the law, and that those laws, because they are written for general or generic problems, then must be interpreted by a court to determine when and how that law may be applicable to individual fact situations. Turn my light so I can see better. There we go. We also discussed the administrative law, which is executive orders and administrative rules and regulations as passed by the administrative branch or executive branch agencies or issued by the chief executive, and what those materials were. We then discussed primary and secondary authorities and index searcher finding tools, and what things fall into which categories. We discussed American law publishing and the proliferation of materials, and how the number of materials we have in different categories has grown significantly over recent years. We also discussed the difference between official and unofficial sources, and then we discussed the different law publishers and the mergers that have taken place and what the current publishing companies are. Finally, we discussed the fact that the ability to do legal research is considered to be an essential skill by the American Bar Association and by lawyers practicing and who are newly licensed to practice, and that having the knowledge and ability to do legal research is essential not only to the practice of law, but also to the ability to work as a paralegal in the field. Does anyone have any questions about anything we covered previously before I move forward to discuss the legal research process? Anything at all? Very good. Legal research is as much an art as it is a science, and it benefits at times from serendipity almost as much as from an actual strategy and organizational structure for how to locate the materials. There are lots of different ways to approach a legal research problem, and there's no single best way to do legal research. In addition, there's no one-size-fits-all legal research process or method. In many, many cases, the process you utilize will be dependent significantly on the nature of the problem that you're researching. For example, if you are asked to find a statute on a given subject, bring me the law on joint conservatorship. In that situation, there is truly no need to do a full-blown research process. You know, you're in the state of Texas, you want the Texas law, you need to go to the Texas statutes, find and codes, find the family code, and then within the family code, look up joint conservatorship and present the text of the statute. There's no real investigation or determination of facts or anything else that needs to be done. That's not a research problem. That's a go get it from the library problem. You already have identified what you need. It's a matter of just locating the specific item that you are looking for. More commonly, a legal research project or problem is a fact scenario. You have a new client who needs something specific, who has a particular problem and they want redress for that problem, or someone is suing them and they want someone to help them to determine a line of defense to defend what they're being charged with. In that case, you do need a full and complete research process because you need to inquire into all of the different issues raised by the facts of the scenario you are dealing with. There are a variety of strategies that can be used to do this type of research, and we're going to talk about two different methodologies for organizing legal research. Any strategy for solving a legal research problem is going to be shaped by the availability of research materials. What do you have to work with? That's a huge question and problem. If you don't know what you have to work with, how do you know what you can search and where you can look? For purposes of this course, while I'm going to show you the books in the library and I'm going to show you how those resources work visually, you're actually going to do the work utilizing online computer systems. We now have not only the Nexus Uni database, but also the Westlaw Campus database. And both of those databases will give you access to answer a variety of legal questions, which you will utilize to answer the research problems as assigned as we go through the course. So we're going to learn how to use the books, at least in theory. And then for the purposes of this course, because I don't have an ability to give you each a copy of a particular set of books we're researching for you to work in those books, nor do we have the ability, given the current COVID-19 situation, to meet in the library. We will actually be doing the research remotely using the databases. And we'll be going over that in the next week or two. So you'll have a pretty good idea of how things relate to each other. We're going to talk in detail about how to search just what you're looking for in order to find the answers that you need for the particular problems. In the book, they discuss two different research methodologies that are useful for organizing any research project. The reporter's questions, and then what they call a general approach to legal research. I will tell you that most students find the reporter's questions more comfortable because they seem more familiar. But most students, once they get into doing the research, find the general approach to be more methodical and more structured and provide them a greater ability to be sure they don't miss anything. While familiarity is a good thing, it is not the only thing, and sometimes when something is very different from things you have done before, it's important to learn how to utilize an alternative method in order to do it. So let's take a look at the reporter's questions. Most researchers are familiar with the typical reporter's questions: who, what, where, when, how, and why. For purposes of this, we're just going to look at who, what, where, when, and how. The why is truly because you've been assigned to do this by your attorney. Why are we looking at this problem? Why are we going through this exercise? Because that's the assignment. As a result, we don't really have any need to discuss the why question, but we will start with the who. In the context of a legal research problem, who refers to the parties. Who are the key individuals or entities involved in this dispute? And who do we represent? Who does our attorney represent? And what do we know about the different parties? Are all of the parties individuals, or are some of them corporations? Or is one of them the government? Is a trust a party or a partnership? It's also important to know the relationship between the individual parties. If the parties on each side are an employer and an employee, that is a relevant piece of information you need to know, and it explains who these people are in relation to each other. And so knowing not only who the parties are, but what relationship they have with each other, or what status they hold, which may impact how they are dealt with by the legal system, all of these things would be relevant in determining this who question, to identify the parties that you are dealing with. What is the question to help you think about and frame the legal issues you're researching? When you initially review the problem, you have to figure out what's the important information. What are the key facts? What are the key facts that are going to help you to figure out what you need to know? And what are descriptive words that you need to think about the research? You may not know which facts are legally significant initially, but as you formulate your issues and you begin to research those issues, the legal significance of certain facts may become apparent, or it may become apparent that some of the things you thought were legally significant are not, in fact, legally significant. The what question is, what is the subject matter? What do we need to know? As you're looking at the facts, you also need to figure out descriptive words you're looking for. As the book indicates, if you've got a case where there's a default on a loan that's secured by a deed of trust, you need to know that another name for a deed of trust is a mortgage. And so you're going to want to investigate not only deeds of trust, but also cases involving mortgages and foreclosures, because they're going to be relevant to the fact situation that you are looking into. Don't take for granted that the facts that you extract from your research problem, from what the client said, are automatically true or are undisputed. You need to take into account what the result might be if it turns out there is a dispute about the facts, or if some facts that your client has given you are proven to be untrue. The reality is that the client does not always tell you everything. And so when you are reviewing a client's file, it's very important to recognize that what information you have may be shaded toward your client and may not be an objective perspective of the facts of the case. You may need to do an independent analysis of those facts to ensure that you're not missing something. So you've got your questions. What do we need to research? What are our issues? You also need to know what are the recommended resources. Where are the best places to look for answers to the questions you are concerned with? If this is an unfamiliar area of law, the first thing you need to do is to get some context or an overview of the subject, to do what I like to call pre-research. In other words, enough of an investigation into the nature of the area of law within which the problem occurs to be able to figure out what the real questions are. And the issues raised are always going to be in the form of a question. If your issue is a statement and not a question, you've got a problem because your research should be answering the issue. And that's why, since the research is the answer, the issue is the question. Once you've done that preliminary research, you've read about the area of law, you can more clearly devise the individual legal issues that are raised by the fact scenario, so you actually have particular questions to research. Where pertains to jurisdiction. Is this a federal question or a state question? Once you've determined the jurisdiction, state or federal, you need to figure out, where do we file this? So which court has jurisdiction? That's what we call a venue question. Which particular place is the proper place for this action to occur? If our client is being sued or is being threatened with a lawsuit, where is the other side contemplating filing the action, so we know what jurisdiction and venue we will be dealing with? Which part of the country are we in? If we're in state court, we know we're going to be dealing with state law, but if you're in federal court, which circuit are you in? Which district court district are you in? Whose law is going to be directly applicable? Which courts are going to be the courts whose actions you are mandatorily required to follow, rather than merely being persuasive authority on the subject? So figuring out the where is important. It's all well and good to find a really good article about how the law of contracts works, but if it's all written about the law of contracts in California, it may be completely irrelevant to the state of the law in Texas. And so you need to know what jurisdiction has priority here, what jurisdiction has the what jurisdiction's law governs the determination of this matter, and look for resources that pertain to that jurisdiction, if they exist. When? Time is a critical element in research problems. If the problem you're researching took place at some time in the past, it's important to know what the law was at the time the dispute arose. So what was the law at the time we got into this problem or situation? Even though you know what the law was at that time, it's also important to find out if there's been any determination regarding the law from that time that the law is not enforceable. So just because the law was on the books and this is allegedly the governing statute when the problem occurred, if at some point that law, that statute you want to rely on, has been found to be unconstitutional, to be unenforceable, It doesn't matter that it was found to be unconstitutional after your event took place. Something that's unconstitutional is unconstitutional from its inception. It doesn't become unconstitutional when the court makes a ruling. All the court is doing is ruling because someone asked them to, upon whether that law is enforceable, and that enforceability goes all the way back to its inception. It's also necessary to remember that just because a court has found something unconstitutional or unenforceable does not take that statute out of the books. Courts don't go around imprinting on books unconstitutional, and they don't have the power to repeal the law. Only the legislature has the power to repeal the law. And if they don't, it doesn't make that law any less unconstitutional. It doesn't make it any more likely to be able to be utilized. It just makes it confusing. In the 1990s, the U.S. Supreme Court ruled that the Texas sodomy law was unconstitutional. If you go to the penal code, it's still there. Nobody gets charged with it anymore because the Supreme Court said it wasn't a crime. The Supreme Court said that so long as the individuals involved were adults and consenting, that the Constitution prohibited the government from making actions between two consenting adults illegal. Period. So the law's on the books, but nobody gets charged and nobody gets tried because the law is not enforceable. But in order to know that, you have to know when the occurrence took place and what has been done since the law went into effect that might impact whether or not that law is still enforceable, whether or not it can be utilized in a given situation. A big question that students have when working on research projects is, when am I done? How do you know when you've found everything? Well, part of that is just plain experience. Part of that is starting to get an understanding of how it all works. And that can take some time. Usually, if you keep looking at the same issues from different perspectives using different search terms, eventually you will find that you just keep finding the same information regardless of what direction you come at it from, in which case you're pretty likely to have found all there is to find. Sometimes you just keep finding more and more things, at which point you need to refine what you're looking at to narrow the scope in order to ensure that you can actually figure out what the rules are that directly pertain to what you are researching. How you do your research can be limited by the use or availability of the resources. If you've been asked to use specific resources or to conduct the research a certain way, that's going to restrict how you do the research. If you only have certain types of materials available to you, that's going to restrict how you do your research. Any questions about the reporter's questions methodology for research? The general approach is an alternative organizational method for research, and it accommodates most problems. I like it because it's a simple 4-step process And even though you go back and forth between the steps, what you do at each point in the process is organized and clear and structured, and it gives you a greater structure to support the research that you are organizing to do. And so I find that useful and helpful. The 4 steps are to identify and analyze the significant facts, to formulate the legal issues to be researched, to research the issues presented, and finally to update everything you've located to ensure that it's good law. We're going to talk about each of the steps individually, but it's important to understand that these steps are related to each other, and nothing you do in any given step is written in stone. You're writing it, and you can revise it. And so there's a certain amount of going back and forth between the steps as you discover new information that impacts what you are working on. Step 1, identify and analyze the significant facts. The first task is to identify the facts of the problem. Some facts have legal significance and others do not. So you start by figuring out what are those legally significant facts and do a factual analysis of the problem you have. A lot of novice researchers like to skim over the facts and just start trying to research things. The problem is your research can't really be productive if you're doing that research outside of your particular fact pattern, because ultimately you're going to need to relate the results of your research to the facts of your individual case. And so it's a really good idea to analyze the facts of this specific problem first, because that can help you tailor the issues you're researching. And the book suggests using what they call the TARP rule to help identify the relevant facts and actually write them down in a form that can make them more usable. TARP stands for Thing, Action, Relief, and Persons. And we'll take them one at a time. The thing is the subject matter of the problem. That's the property involved, or the place involved, or the thing that you're arguing about. If a consumer is harmed after taking a prescription drug, the drug is the thing. If it's a dispute about the title to a piece of real property, the real property is the thing that is the subject matter. So what is the thing that forms the basis of the dispute? That's your T. Once you know what that thing is, the next question is, what is the cause of action? If your client is wanting to sue someone, what's the cause of action they can sue for based on the facts that you have? If your client is being threatened with a lawsuit, you want to know what the other side's cause of action is and what your grounds for defense are. Either way, this all falls under this A for action. What is the relief sought? What does your client want out of the case? Are they looking for a judgment, money for compensation for the harm they suffered? Are they looking for an injunction, an order from the court to tell somebody to stop doing something that they believe is harming them? Are they looking for an apology, which usually a court doesn't have anything to do with, but sometimes you can negotiate? So what exactly does your client want out of what is going on? If they're being called on to defend an action, they want you to show that they're not responsible. If it's the plaintiff, they want you to show that the other side is responsible and they should be entitled to some form of compensation. But you need to know what the relief sought is. What is the end game? What do they want out of the case when it finishes? And finally, the P is who are the parties? The persons or people or parties involved in the problem. You want to know not only who they are by name, but also their functional and legal status and their relationship to each other. Are the parties individuals? Are they a group? Is it a corporation? Are there relationships between the parties that impact how they relate to each other as it pertains to the particular facts of this case? So you need to know, is this a dispute between a husband and a wife, or an employer and an employee, or a beneficiary of a trust and the trustee? Any type of relationship between the parties that might color or otherwise impact or influence what is going on is an important piece of what's happening. Once you've identified all of those entities, so you've identified the thing, the cause of action, the relief sought, and the parties, the next step, step 2, is to formulate the legal issues to be researched. This is the initial thought process and questioning of what under the substantive law your client can do or what they should be able to do. And if you don't know anything about this area of law, this is the point in this research structure where you will also do pre-research. This is where you're going to read the legal encyclopedia and find out everything you can about this area of law so you can figure out how it works. Because once you've figured out the nuts and bolts of the particular subject matter area of law, it's a lot easier to figure out what the actual questions are you need answers to in order to resolve the dispute. Once again, recognize that when you are creating concise statements of each legal issue, you're going to make those issues in the form of a question that then your research will attempt to answer. Writing a clear, concise statement of each legal issue raised by the significant facts is important, and it can be difficult. And sometimes you write issues that then when you go to organize them, you realize are all parts of each other. And sometimes you figure out that some of the issues you wrote are insignificant, and some of the issues you wrote are so broad that you need to narrow the scope because you're finding so much information you can't figure out what it all actually means. After you have written clear, concise statements of each of your questions, and you will write them in the form of a question, the next step is to create an outline. Take all of the issues you've written and figure out an organized and orderly way to write them out, to put them in an outline, which will then form the structure of your research problem. So what's the most important question, and what's the next most important question, and so forth. And which of these questions I just wrote are really just pieces of other questions, of other issues. And so they ought to be subparts underneath an overarching issue. The goal being to create a cohesive outline for the research problem, which then gives you the structure for conducting your research into the answers to each of these questions. Recognize that it's important to keep notes of all of your research. Every time you think you find something, write down where you found it and what it is and what question it answers. It's often a good idea to make a photocopy of a page of the front page of whatever resource it is, or take a picture of it, or a screenshot if you're doing it online. The last thing you want to have happen is that you are trying to recreate the search you did because at the time you didn't want it because it was what you found was pertaining to another question than what you were looking at, and now you're trying to recreate the serendipity that helped you to find it in the first place. You're going to write your outline. You're going to set it up on multiple sheets of paper if you take notes on your research in handwriting. You're going to organize it with lots of wide open space in a document if you're typing your notes to give places to put information on the different individual questions. Step 3 is to do the actual research, to research the issues presented. And you're going to do this with an organized plan. So for each issue, you're going to say to yourself, okay, do we know there's a statute on this, in which case statutory research should come first? Or do we know there is no statute on this, so we need to look to case law to see how the courts have interpreted and explained how to do this? Which resources you want to tap first to look for information is going to depend significantly upon the information you are looking for and what you know about it. Where it gets a little convoluted and is interesting is when you're researching question 1 and you find something that Foursquare answers question 3. Do you say, okay, I'm going to come back to question 1, but let's follow what I just found for question 3 until I get a full and complete resolution, and then I'll go back to wherever I was? You can do that. The problem is you're likely to luck into something else and then something else and then something else, and all of a sudden you're letting serendipity drive your research rather than your organizational structure. And when you're letting serendipity do the driving, you often end up with a lot of holes in what actually needs to be looked at. That's a complicated thing. So my recommendation is that when you find something that pertains to an issue that is not the question you are currently investigating, you take time to summarize what it is you found, to notate the citation for what you found and where it is and why it's important, and to take a picture of it or make a photocopy of it or otherwise scan it so you will have direct access to it again when you start looking at that particular question. So you grab onto serendipity, you write it down, you keep all the information you need, but you don't let having found something divert and distract you from what you are working on, so you don't end up with holes in your research because you missed something you should have been paying attention to. As you're going along, the results of your research may show that your issue is too broad, in which case rewrite it to narrow the scope. Or you may be finding nothing because your issue is so limited that you can't find anything that falls in exactly the right place, and you need to broaden what you're looking at a little bit in order to ensure that you don't miss anything and that you make sure you get good answers to the questions. Maintaining an accurate list of sources consulted, the terms you've checked and used, the resources where you have located information, that record keeping will keep your search on target and on track and ensure that you can recreate the research if you need to and know where to go to explore for more information as you are going along. You can't always complete one issue before you go to the next issue. They overlap, they bleed into each other. What's most important is that you keep your information straight, that you keep really, really good notes of what you found and when you have found it, and more importantly, where you have found it, so that you can recreate that research as is necessary to justify the determinations that you're making in this regard and to substantiate the rule of law in making those determinations. For each individual question, you're going to decide, are we going to identify, read, and update the relevant constitutional and statutory and provisions and administrative regulations first? Or are we going to identify, read, and update all relevant case law first? Sometimes one is the right answer and sometimes the other is the right answer. It depends upon the subject matter. With regard to statutory law, you can use secondary sources and finding tools as resources to drive locating the primary materials that you need. It's not uncommon to use the legal encyclopedia to give you a sufficient overview of the material to understand the area of law, but to also use the footnotes to the encyclopedia's black letter statement of what the law is to shortcut your research, in that the footnotes may have citations directly to the part of the code that pertains specifically to the matter that you are looking at. And so while the encyclopedia is a great resource for pre-research, it may also be a great jumping off point for your actual research in using it not as an authoritative source, but as a resource to help you locate primary law materials like case law or statutory law that substantiates the rule that is discussed in the text of the encyclopedia. So you may look at at secondary sources. You may look at statutory compilations, including those tables of contents and indexes that can help you find things by subject or topic. It's important to locate it. You may use electronic legal research from online resources where the resource itself is not only the index search and finding tool, but also the repository of the particular information. You can't always identify all the relevant statutes at the beginning, but recognizing one can lead you to another, to another, to another. So it can be a methodical process. Same with the relevant case law. It's also really important to remember that you need to research both sides of any question. It's not enough to know what resources support what your client wants their argument to be, your client's view of the world. You need to know what the other side's argument may be to your issues, because you not only want to put forth your own argument, you want to be able to counter the other side's arguments to the contrary. And so you need to know both sides of any question in order to ensure that you get all of the relevant information and that you're sure that your argument will be ultimately accepted in comparison with what the other side is saying. It's also important as you are reading cases to recognize that no two cases are exactly alike. And so you may not find a case with the exact same fact pattern. The key is to figure out if the differences in the facts between your case and the case you're looking at are sufficient to result in a differing outcome, or if they are essentially irrelevant differences that don't make a problem that you need to work with or worry about. You can find cases that interpret statutes through annotated statutes and codes. You can find them in treatises and loose leaf services. You can find them utilizing citators, that is, by shepherdizing or looking in the citator for the statute and looking to see what cases are located therein which discuss that particular statute or provision. Once you've identified relevant cases, you can locate other cases on the same subject using the key numbers and topics from the West Digest that are contained in the case that you're wanting to rely on. You can also utilize Westlaw or LexisNexis. You can use Keysight or Shepard's to update the material to find other cases that are citing your case. You can also verify that the case you want to rely on has not been overturned at a higher level. As you read and brief each case, you need to make sure you have the full citation, any parallel citations, the judge and the court that issued the opinion, the date of the decision, the relevant facts. All of those are going to be important when you want to cite that particular resource for a point of law. And so you need to keep and maintain all of that information at your fingertips. You're going to want to refine the search as you identify materials. You're always going to want to be narrowing the scope a little bit at a time to get to exactly what it is you're looking for, if there is something directly on point. And if not, to try to narrow the scope as much as possible to avoid such a flood of information, especially a flood of conflicting information that makes it difficult to figure out what the rule of law actually is or should be. Finally, you're going to update. You're going to shepherdize all statutory materials, all case law materials, all secondary sources that you're relying on to validate the opinion you're putting forth, the argument that you are putting forth. The reality is that statutes are changed, new statutes are passed, old statutes are modified, repealed, amended. Case law creates new decisions, issues new opinions. Courts can issue new opinions. There's a lot of material that you can derive by updating that can directly influence the extent to which the materials you want to rely on are still good law. And it's important to do that updating, to do that shepherdizing in order to ensure that you don't miss something. And that the materials you're looking for, the materials you're wanting to rely on, are still good law. How do you know when to stop? That's a really, really hard question. And the less experience you have, the harder it becomes to know when to stop. There's no uniform rule. Occasionally, when you're researching a problem from all the different sides, you keep ending up in the same point, the same place with the same information. If you keep rewording your issues, but you still end up in the same place, that can be an indicator that you found what there is. Alternatively, it can be an indicator that you are writing your issues in such a way that it's only leading you in one direction and not giving you any alternatives. Both of those factors are important to consider. The reality is that sometimes you just have to guess as to whether you're done. And over time, you'll get more experienced at knowing what it feels like to feel like you've actually found all the information that you need. The two different approaches to research have very similar components. There's a lot of overlap. The processes themselves are somewhat different. I think the second one closes the loop a little bit more, and I think each step relates to each other more clearly. The other one at least uses words you're familiar with and structures you're familiar with, and so that is also very appealing. Legal research is a process. It's not a road. There's rarely one single way to go through to accomplish the particular task at hand. You can encounter alternative theories. You can hit dead ends because everything you think is going to be relevant turns out to be nothing. You often have to revisit your initial impressions and theories and rework your questions, rework your issues until they start to glean specific information. That's the strategy side. Taking the notes and making sure you keep track of what you found and where you found it. That's all part of the strategy. Having that structure and that strategy makes you open to serendipity, makes it more likely that if you luck into finding something, you will identify it. You will recognize it as something that has been identified and have the ability to act on what you've seen in a methodical and orderly manner. Always remember that there's no one way to do this. And sometimes one way works better than another, and sometimes it's the other way around. You need to do what works for you. The most important thing is the record keeping. As long as you know where you've been and you know what you've found, you are unlikely to get into trouble because you don't know where you're at or you don't know how the things you've located fit together. And that's the important question. I guess y'all are as tired as I am today because nobody's asking any questions. In the other two classes, I had a lot of questions, so we barely got here by the end of the hour and 20 minutes. Since we are on target with where both the Monday, Wednesday, and the Tuesday, Thursday morning classes are, I am going to stop here rather than moving forward into something that we haven't yet dealt with in the other classes. I don't want to get y'all too far ahead of everyone else. For next time, I understand that completely. For next time, please read chapter 3, and you can go ahead and begin reading chapter 4. If you do not have your book yet, I will be happy to email out chapter 4 as well. I'm going to have to not send you too many more chapters after the first 4, or I can get into copyright trouble. But there are copies of this book available, new and used, and purchase and rental from a variety of online sellers at reasonable prices. Unlike the intro book, where the prices have been going up high, they should have this research book back at the library at Northeast. They are really supposed to be stocked there. I would contact the library, the bookstore directly. These books should not have been canceled. If they were not done. That was not done on my instruction. And I've had a lot of students who ordered them and who said that their research books were back ordered. I understand canceling the intro books because they couldn't find them, because they're now out of print. But research books should be available. If you still do not have it, or your book is on its way but it's not here yet, please do email me and I will email out chapters 3 and 4. But it's really important that you get a book, because when we get to chapter 4 and beyond, I'm going to be looking at illustrations in the book where there are pictures of resources, and that is an important function. My understanding with regard to the intro book at the bookstore is they don't have any. They're taking orders and then they're sending cancellation messages. I don't know why the computer's taking an order and then they have to send out a cancellation message. But the research book, the book for this class, should be available. When we start doing assignments, people will be given as individual assignments where they have the same assignment as other people. So I'll be putting you in breakout groups to help work on things. The sooner you get to know a little bit and work together, the easier this process. I do recommend working with each other, setting up study groups. All of that really does work very, very well. Yes, Naracha, I did get you on the roll. Thank you for checking. And while the assignments will be turned in individually, you will have the opportunity to work together in groups of 2 and 3 and larger, depending, in order to be able to do it. Tamara, I saw you were here and that it kept dropping. I know there have been some issues with the internet. The rain over the last day or so has not been helpful with keeping things running. But a lot of people who are in this class are also in intro or are taking both classes, whether they are in the Tuesday, Thursday night class or the Tuesday, Thursday morning class or the Monday, Wednesday morning class, as there's a lot of overlap. So we can make it work. You will not have to work together as a group. Each person will turn in their own assignment, but the assignment you have will be the same assignment that someone else has. And my recommendation is that 2 or more of you work together in doing that assignment so you can explain to each other how to do it. You're still going to do your own work. It's not a group assignment where you turn in one paper for 3 people. My recommendation is that when you can explain to someone else how to do something, you find out that you actually really know how to do it, and vice versa. And if there's something you're having trouble with, someone else can explain it to you, and then you both know it as well. That's what I'm looking for. Any other questions? If not, I'm going to stop the recording on the session.